Hello, my name's Osha. Today I'm going to be discussing the Katz versus United States case, which focuses on the Fourth Amendment, and uh, it expands on the exclusionary rule as well. Now, first of all, what I'm going to do is because this is discusses uh, the law. I want to give a disclaimer. I'm not an attorney and I'm not licensed to practice law in any state in the United States. However, I am a lawyer. There's a difference between a lawyer and an attorney, right? Just bearing mind the phrase all attorneys are lawyers. Not all lawyers are attorneys. You can check the dictionary for clarification or just Google it. So I'm a lawyer. I hold a Juris Doctor degree. That just means that's Latin for Doctor of Law degree from George Washington University Law School in the United States. It's in Washington, D.C. So today I'm going to be discussing the Katz versus United States case. It's a landmark case, 1967 case that expanded, um, the Fourth Amendment jurisprudence and took it away from just, uh, you know, uh, persons, houses, and took it away in just from actually houses, papers, and effects. Right, took it away from just things and moved it beyond the traditional trespass doctrine to a um, a privacy issue, right? Even when one is in a public area, but it made it, it extended it to a privacy sphere, a privacy law. So I'm going to give a brief history, and this is particularly important right now, considering the ice raids. Right, the ice raids that have gone, they've become notorious. They've led to unlawful detentions, extended detentions, and even deaths. Right. Um, Now, note that ICE, the immigrant that deals with immigration, and immigration is actually a civil matter, right? So it's not criminal. Fourth Amendment deals with criminal cases, criminal warrants, and criminal arrest. Arresting someone and seizing someone because they're suspected of a crime, right? They're suspects for a crime. But the ICE raids by ICE officials, what they have don't constitute arrest warrants. Um, they are, they're within the jurisdiction of civil matters, right? And it's to pick up, somebody, an illegal alien, so that they can be presented in court for civil proceedings concerning immigration, and they can pick them up in a public area, but it's not an arrest warrant or search warrant to enter the illegal alien or the suspect's home, right? They're not suspected of committing a crime. It's a civil matter. Now, that's it's not ICE I want to discuss, right? It's what I want to discuss is the Fourth Amendment. Because I like talking about American presidents, and the Fourth Amendment was included in the Bill of Rights, which was authored by our fourth president, James Madison. Now, importantly, uh, the Katz versus United States case of 1967 also overturned um, overturned a prior case that had been controlling. That's the Olmstead versus United States case of 1928 that was presided by our 27th President William Howard Taft when he was Chief Justice of the Supreme Court. And of course, um, he uh, what was dispositive in that case was that the Fourth Amendment required a trespass. So there was a traditional trespass analysis, and what the Katz case did was it overturned that case, and it expanded the Fourth Amendment protection from just places, right, to privacy as well, right, to privacy of the individual. Importantly, the justice who wrote the majority opinion, Porter Stewart, emphasized that the Fourth Amendment is about persons and not places. And this is very important. Now, let me give a quick backstory or history of these exclusionary laws, exclusionary rules. Um, so, but before I'm going to do that, let me remind us of what the Fourth Amendment is. Let's go to the text of the Fourth Amendment. So, the text of the Fourth Amendment is very important. It's crucial because the words, the sentence, the statements by the justices, you'll find out that even though it appears they're flowery at times, the words are not frills, they're not mere ornamentation. All the words in their sentences are actually very substantive because later on they analyzed by later judges and lawyers, and they become a rule. They establish doctrine or methods or systems, right? And they're the cornerstones of our legal system, of our legal architecture, right? So again, the Katz case is very important. It's considered the king of surveillance cases, and today it's still used. It became a watershed case in Fourth Amendment jurisprudence, and it's considered a bulwark against wiretaps and emerging forms of surveillance, right? So I'm going to first of all read the text of the Fourth Amendment and get it out of the way and provide a history of the uh, exclusionary rule, because the Katz case also, what it's doing is it's saying, talking about evidence that cannot be used, right? What's inadmissible in court, and I'm gonna expound on that as I proceed. But let me first read the text, and I'm reading from memory. Of course, it's also important for me to sort of uh, test my memory, because one, I'm doing this in a very bare bones way. I'm just recording myself and just talking, so I can't easily get it's not comfortable. It's not convenient for me to get carry my computer at this moment and be reading from from the screen. So I have to memorize sometimes, and I'm also memorizing also just to test myself. I've talked about how I was shot in the head by the police. These are actually stitches. They look like wrinkles, but they're actually stitches. I was shot in the head on May 16, 2023 by a rogue cop, a racist rogue cop by the name of police officer Jeffrey Ray, from a Fourth Amendment violation that occurred in my home on May 16, 2023. So to make sure that my memory and everything's still functioning properly, I have to test myself, right? So it's as if the rogue cop or the police, somebody wanted to, I don't know, they intended to harm me. And, where they chose to shoot me is a very important area. It's a very significant area. Uh, the left portion, that's called the Broca's area. It actually controls fluency, analytical thinking, and memory. But the police shot me right there. So it's one of the reasons I also continue to test my memory and do these videos. So the text of the Fourth Amendment. So it starts. The Fourth Amendment, it says the right of uh, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and persons or things to be seized. So that's the text of the Fourth Amendment. This time, I think I said it properly from memory. Let me repeat it. So, note all these things are very important. If you were just to paraphrase and show the substance or your understanding of the Fourth Amendment, I would just typically say, well, the Fourth Amendment protects us against unreasonable searches and seizures, right? Uh, uh, without probable cause, and without uh, a warrant from an impartial judge, right? That's typically it, right? They have very important things. But again, they've left out other very important things that are litigated in court. And these things come up in Olmstead versus United States. They come up in Katz versus United States. So notice I paraphrased without talking about the persons, houses, places, and effects. So let me repeat it again. All those words, they're not mere frills. It's not ornamentation. They're very important. They're relevant to the case, right? They're relevant to the amendment and subsequent judicial history and laws, right? And rulings concerning Fourth Amendment and our protections. So again, and the Fourth Amendment is one of those cases that protects the rights of the accused. Rights of the accused cases amendments are Fourth Amendment, Fifth Amendment, Sixth Amendment, Seventh Amendment, and Eighth Amendments. They pertain to rights of the accused, and of course, Fourth Amendment is one of the most litigated and the most explored amendments of the U.S. Constitution. Amongst the most litigated and explored include the First Amendment, often called the most famous amendment because free speech, that's what protects Hollywood and artists, famous people. So they call it the most famous case, the most famous amendment because it deals with expression, freedom of expression, freedom of speech, right? And that's what, of course, Hollywood uses. Our famous artists, that's what protects them to express themselves. So it's called First Amendment is often called the most famous amendment. Um, Second Amendment is often heavily litigated, but I think mainly because people think it's no longer relevant, right? That's people think we shouldn't have guns. That's Second Amendment is right to bear arms. So it's very controversial, right? It's not about protecting our rights. It's more about hey, is this still relevant? That is the Second Amendment very relevant, and it's a heavy media issue, and so it often divides the state. Um, it often divides the states. You know, you say half and half. Maybe the blue states don't want it anymore, think that the Second Amendment right to bear arms is redundant. Red states in the South, they think no, it's still relevant. So you see, that's the basis of that Second Amendment controversy. And what else is controversial? The Fifth Amendment, everybody knows it from Dave Chappelle's skit. You plead the fifth. That's your right to remain silent, not to self-incriminate. But the Fourth Amendment, it deals with everybody, right? Because it deals with the government's ability to invade our homes, right, the places, or our privacy, right, and to charge us, to use evidence against us. So all Americans you know, uh, are concerned about the Fourth Amendment. You don't have to be a Republican or Democrat, right, to be interested or disinterested about the Fourth Amendment. So it affects everybody. So it's probably arguably the most litigated, the most explored amendment in the Bill of Rights. So I'm going to repeat. Just going to repeat the text again because it's very important. All the words are not frills, they're not mere ornamentation, they're actually very crucial. Uh, so, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue except up. Sorry, I want to use the words exactly. The words, it doesn't say except, it says but, even though they're similar. But upon probable cause, uh, supported by oath or affirmation, and particularly describing the place to be searched and persons or things to be seized. I want to make it smooth, so I'm going to say it one more time. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches or seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and persons or things to be seized. That's the Fourth Amendment. That's its text exactly as the founding fathers gave it to us. So now let me go to the history of the exclusionary rule, right? Because what the Fourth Amendment, right? What the Katz case and the Olmstead case, what they were, what they were contending about was that can the evidence used by the government to convict the defendants, can it be used? Is it admissible in court? So they're arguing that they should exclude that evidence because when the government charges you for a crime, it's their responsibility, and the standard in the U.S., in the English common law, which we use in the United States, is the government has to provide evidence, to a jury or a judge. The defendant, because it's a criminal case, they have a right to a jury, right? And a public trial, they can choose to waive it, but they have to provide it's the government's responsibility to provide the evidence in court to a trier of fact, right? To a fact finder, and to prove beyond a reasonable doubt that the defendant is guilty of the crime. So the Fourth Amendment, this case that we're talking about, the Katz versus United States, is trying to say, look, evidence, the way it was obtained by the government, because it was obtained in an illegal manner that violates the Fourth Amendment, that it cannot be used. It should be inadmissible. It should be suppressed. It should be thrown out, right? And so if you don't have evidence, the government doesn't have evidence in a court, then the cases, they can't win, they can't prove their case beyond a reasonable doubt. It can be dismissed, right? And so I'm going to provide the history of the exclusionary rule. Started with the Weeks versus United States in 1914, where it was, it was ruled that evidence obtained illegally by the government is inadmissible in court. That's Weeks versus United States in 1914. Now, in 1920, there was a Silverthorne Lumber Company versus United States case, which established which is the origin of the fruit of the poisonous tree. But that fruit of the word fruit was not used. The metaphor fruit of the poisonous tree was not used, right? What the government, basically the substance that they established regarding the inadmissibility of evidence was that evidence that was originally obtained in an illegal matter, right? Its derivative, right, is also inadmissible, right? Derivative, the fruit, the derivative of evidence originally obtained in an illegal manner is inadmissible as well. So it was not until the 1939 case of Nardone versus United States that Justice Frankfurter used the metaphor fruit of the poisonous tree, and that case was also dealing with illegal wiretap. So fruit of the poisonous tree. So that's the fruit of the poisonous tree. The poisonous tree is illegally obtained evidence originally, right? And its fruit, any derivative from it, right? Any benefit, any other evidence. The government, because the original evidence was obtained illegally, the government cannot use its fruit, and they can't benefit from any corresponding evidence or from or corollary evidence from that originally illegally obtained evidence. So that's Nardone versus the United States, 1939, right? And so Weeks, so that exclusionary rule, the Weeks versus United States of 1914, those exclusionary rules initially applied to the federal government. Now, another case came up in Mapp versus Ohio in 1961, and it applied the exclusionary rule to the states through the 14th Amendment, right? I've mentioned that the 14th Amendment and the Fifth Amendment, they deal with due process of law. The Fifth Amendment applies to the federal government, and the 14th Amendment now applies these due process laws to the states. And Mapp versus Ohio in 1961 applied the exclusionary rule to the states. So now I'm going to go into the Katz versus United States case. But before I do that, let me actually just give a quick summary of the case that it overturned, right? That's the Olmstead versus United States, which was decided by, it was presided by Chief Justice Howard Taft, and he wrote the opinion. And to him, he applied the trespass rule. And he said that, look, that there's no Fourth Amendment violation. It had to do with wiretapping as well. This guy, Roy Olmstead, he was a bootlegger. He was suspected of bootlegging, and he had his office. So what federal agents did was they placed, listening devices, wiretaps on his phone lines, which were, on the streets. They did not have to enter his house or his property or his offices. The wiretaps were placed on the phone lines that were outside. So Justice Taft ruled in Olmstead versus United States that, well, since there was no trespass upon the property of Roy Olmstead, and the wiretaps were outside, were put in a public area, there was no intrusion, there was no physical intrusion. So to him, there was no, and to the court at the time, there was no Fourth Amendment violation. So the Fourth Amendment during the time of Justice Howard Taft in Olmstead versus United States, the controlling decision was that there had to be some kind of physical intrusion. It was, it was viewed from a traditional trespass analysis, right? And that's how the Fourth Amendment was viewed at the time. But now Katz versus United States now overturned this. Now, let me give the backstory of Katz versus United States. So, Katz was he was a bookmaker. He was gambling. He was dealing with suspected of illegal gambling, and so he had and this happened in L.A. I think Sunset Boulevard. He had there was a public phone booth that he used regularly. It was close to his home, his apartment, and he'd just walk to the phone booth, and he'd go and make he placed his illegal gambling bets over the phone, and the FBI suspected him of this. So what the FBI did was they placed wiretap devices within proximity of the phone booth, but not inside. They didn't have to break inside they didn't have to enter the phone booth to place the wiretap devices. It was outside the phone booth, but it allowed them to listen to the conversations, at least his end of the conversation, right? And so they used the information that they gathered from the wiretaps that were placed outside the phone booth, but within proximity, and could overhear the side of um, uh, Katz's conversations. And so they used that to convict him in court. So he was convicted of, interstate, gambling, illegal gambling. He was making those calls into their interstate calls. So he was convicted. He appealed it to the Ninth Circuit, right? The Court of Appeals, the Ninth Circuit. The Ninth Circuit supported, they affirmed the conviction, saying that, well, there was no physical intrusion, because so they used the traditional trespass and analysis of Olmstead, right? Which was still controlling, and so they considered that, well, the wiretaps, did not intrude on they did not intrude on the um, there was no physical intrusion of the phone booth, right? Um, so And then eventually he appealed to the Supreme Court, which granted certiorari, right? So certiorari, that's just the right of the court giving you the opportunity to review your case, to listen to your case, to make a decision. So, however, the Supreme Court now, established a watershed in the Fourth Amendment jurisprudence when they expanded the Fourth Amendment from just a places, a location, uh, a trespass protection, and expanded it to privacy. Right? They made it that the Fourth Amendment is about privacy as well. So um, the justice who wrote uh, the justice who wrote the majority opinion was Potter Stewart. Chief Justice Earl Warren, a very significant, one of our most significant Chief Justices, was, of course, the Chief Justice at the time. But Potter Stewart wrote the majority opinion, and he famously, what was most important was from his writing was that he established that the Fourth Amendment is about people and not places. It's about people. So and he strengthened the idea that the Fourth Amendment, he reinforced the idea that the Fourth Amendment deals with privacy as well. And in it, he was talking about how um, that because the Fourth Amendment had been viewed as having to do with getting a warrant to be able to enter your home, right? That it's your home, it's about your house, your property, the information there, and the police, the government needs a warrant to be able to get there to seize you or to get access to your information. So, however, and in fact, it was Justice John Marshall Harlan II, who expounded more on what Potter Stewart was saying, Justice Potter Stewart was saying, and he established the famous two-part Katz test, which we use today. And that's basically saying that the Fourth Amendment deals with a reasonable expectation of privacy as well. Reasonable expectation of privacy. So this is what Justice um, John Marshall did. He expanded, he expounded more on what uh, Justice Porter Stewart was saying, and he said, "Look, while the Fourth Amendment is about persons and not places, it is also about what um, the the individual, the subject, right, uh, chooses to keep private, what he wants to keep private, and also what he knowingly exposes to public view or the public, right? It could be in his home, right? And it also and also he extended it onto even public spaces, a public area, but where he exhibits an intention, a desire, an intention to keep information private, even though he's in a public area. And because, this case was dealing with a phone booth, a public phone booth. It wasn't the home of Charles Katz, it was a public phone booth, right? But because he was dealing with, he exhibited his desire to keep his conversation private because one, he closed the phone booth, even though it was a public phone booth. He closed the door of the phone booth, right? And also because once he paid his toll, he wanted a private conversation. He didn't expect um, the public to be able to access what it was he was discussing. So he said he demonstrated a reasonable expectation of privacy. So the Katz two-part test is basically saying, uh, did the defendant demonstrate, did he exhibit an expectation of privacy? And was that exhibited expectation of privacy? The second part is it reasonable to society, right? Does the society find that expectation of privacy that the defendant exhibited, is it reasonable? Yes. In the Katz case, because, yes, the society expects that a person using a phone booth who shuts the door, right, pays his toll, he can expect, it's reasonable for that person to expect privacy, right? So there was a reasonable expectation of privacy demonstrated in a defendant who pays his toll to uses a phone booth and he shuts the door. So that's the two-part test of the Katz case. And this has become the standard for Fourth Amendment jurisprudence as well, right? So it takes Fourth Amendment just beyond, the government invading your home, and of course it's expanded into things, modern surveillance technology such as GPS, right? So the answer to can the government just place a wiretap on your car 24/7 without surveilling you with a GPS 24/7 without getting a warrant? No, the government can't do that. They require a warrant to be able to do that, right? To be able to surveil you, place a GPS on you 24/7. The government requires a warrant, right? So I've tried to pretty much touch on the Fourth Amendment, which has become more complex today because of, surveillance technologies. They have drones, and importantly, though, what's dispositive is regarding the two-part Katz test is what is it that the defendant, the individual, knowingly exposed to the public. That when a defendant, a person knowingly exposes, information or objects to the public, then he has shown that he doesn't expect there's no Fourth Amendment protection because he knowingly made that exposed that information or that object to the public. So there's no expectation of privacy. There's no Fourth Amendment protection there, right? But what he shows an intention, to keep private, right? Well, for instance, in the Katz case, when he goes into a phone booth and shuts the door, pays his toll, then he demonstrates an expectation of privacy. And the second part, it's reasonable. Society considers it reasonable, right? There's a reasonable expectation of privacy there. So that's the Katz case, and I'll do because the Fourth Amendment is so complicated today. It's very complex, and as I said, like ICE raids, they require the ICE warrants, official warrants, they're administrative warrants, and they're not criminal warrants. They're not arrest warrants. So those the for instance, when an ICE official comes to uh, a party's home, to take him to the court, they have the what they have, the official warrant that they have, the ICE warrant they have is to arrest him if he's in a public area. They find him is in a public area. But the Fourth Amendment protects you in your home. The government has to come with an official arrest warrant or search warrant, an arrest warrant from a judge, an impartial judge, right? Signed, you know, specifically identifying you and identifying the place, right? To take you to arrest you. So if you're in your home, you have a right not to open the door, right? An individual has a right not to open the door. So similarly, like I've talked about my situation with an emergency evaluation petition, right? That was, first of all, it was fabricated, but I'm not even going to, which meant it was an illegal EAP, but I'm not going to talk about that. But an EAP as well is not an arrest warrant. So if I was in my home, which in my case I was, if I shut the door and I never opened the door, the police can't take me. They can't seize me in my home or even in my corridor, in my curtilage, right? I'm protected, right? If they see me in public, and then there's also a requirement that I've got to be uh, endangering myself or the public, and there are procedures to give me notice and all that. So an EAP is not an arrest warrant, neither is an ICE, an immigration, uh, an immigration document warrant or whatever to take one to for an immigration proceeding. It's not That's not an arrest warrant as well because immigration is civil and not a criminal case. So Importantly, that's Katz versus the United States, 1967, which overturned Chief Justice um, William Howard Taft ruling in Olmstead versus the United States, the which had limited uh, the Fourth Amendment to a trespass analysis, trespass and physical intrusion case. So the Katz case expanded Fourth Amendment protection to privacy, personal privacy. Now, importantly, let me mention that why I was also stating that the words in the Fourth Amendment text that I read from memory at the beginning, they're very significant because there was one dissent, so it was 7-1, right? The majority um, overturned the conviction of Charles Katz, and it overturned the ruling of Olmstead versus the United States. So the majority thought that the that Katz's privacy had been violated, and of course they created a watershed, uh, you know, moment for Fourth Amendment jurisprudence by establishing that the Fourth Amendment protects personal privacy, right? And the government needs a warrant to be able to violate that. Now, importantly, the one dissenter was Justice Hugo Black, and Justice Hugo Black, referred us. He compared what he did was he likened the wiretapping to eavesdropping, and he said that look, eavesdropping occurred during the time of the drafting of the Bill of Rights. That eavesdropping was extant, right? It existed during the time, the drafting of the Bill of Rights. And they said that if the drafters uh, meant that the protection was beyond the searching of persons and places and the seizing of things, if it was beyond that, right, which the traditional trespass analysis, circumscribed or confined the Fourth Amendment protection to, then Justice Black was saying that if it applied to eavesdropping as well, they would have included it in the language of the Fourth Amendment, but they didn't do this. They failed to do so. So it was his contention that personal privacy was not intended. Personal privacy was not intended in the by the framers in their design of in their drafting of the Fourth Amendment. That's the contention of Justice Hugo Black. And you see that the language is very critical because justices will analyze the language, but of course the majority, uh, which was written by the majority opinion, which was written by Justice Porter Stewart, they didn't agree. They contended that the Fourth Amendment, as drafted by the framers, was about persons, and it dealt with personal privacy, and of course it was eloquently articulated and systematized in the two-part Katz test by Justice John Marshall Harlan II, by establishing that there was a reasonable expectation of privacy that was to be protected by the Fourth Amendment. Again, let me read the text of the Fourth Amendment and I'll sign off. It's the people, right? The people, the right of the people, and that's how we started. So it's about the people, American people, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and persons or things to be seized. That's the Fourth Amendment. I hope I've clarified. I'm going to do subsequent videos and addressing individual points, parts of the Fourth Amendment, which is very complicated, of course, but very significant in these times of ICE raids. My name is Olurotimi Osha. I like talking about American presidents, and I'll keep you posted. Thank you.